if it were, then it's a fraud on the Constitution. It's an absolute fraud on the Constitution if you admit that this had a nexus with your object on 18th of December as applied to J&K with any permutation
even
and
if you were
combination.
to exercise this power, according to you, in relation to any Indian state,
that's right.
This would be unconstitutional.
That's right.
Irrespective of the special considerations which apply to J&K in relation to 370.
Yes.
You can convert a UT into a state, but you can't do the reverse process. That's the
right.
second point.
And that is historically, that is what has happened. So by call it a suspension or a
so, Mr. Singh, are you approaching it from the perspective of Article 356, that the power under Article 356 cannot be used to achieve these ends, such as the suspension? I mean, how are you further exploring the point?
Yeah, unless this was in furtherance of the object of 356 and it pertained to a body or authority of the state. Here, the suspension is of a constitutional provision which deals with consultation with the representative body of the state, which is the legislature of the state, the legislative assembly of the state. Now, this can't have even the remotest nexus with an Article 356 object to suspend consultation with the legislature of a state, or even, I'm now arguing against myself, or even the substitute for that legislature, which is Parliament, to suspend that consultation altogether, can't have any nexus with the object of 356. 356 is for the purpose of, because the Constitution hasn't been working in that state, or the state isn't able to be governed as per the Constitution, and therefore there's a temporary suspension. And your Lord, I don't want to go into repeat arguments on 357.
The argument on your side has been that 356 is for the purpose of restoring democracy, not for abrogating. That was the argument.
That's right. And this, unless the union were to tell your lordship when they start their arguments, whenever they do, unless the union is to tell your lordship that yes, it was an object of Article 356 to change Jammu and Kashmir from a state to a union territory, they can never justify this as having any nexus with the object of 356.
Therefore, there are two distinct arguments. Therefore, one, whether the power under Article 3 can at all be utilized to convert a state into a union territory. That's one.
That I'll come to subsequently.
And the second, whether this power was correctly utilized or constitutionally exercised at a time when Article 356 was in operation. Does Article 356 empower the union to do this?
That's right. But
there are two different areas which we would like to hear from you very briefly.
I'm very grateful to my Lord the Chief Justice, but this is one step before that. I'm saying that if you read, it says, make such incidental and consequential provisions as appear to the President to be necessary or desirable for giving effect to the objects of the proclamation, including provisions for suspending in whole or in part the operations of any provisions of this Constitution relating to any body or authority of the state. So my argument here is, one, such the para C2 can never even remotely be for giving effect to the objects of the proclamation. On 18th of December or 19th of December 2018, the object of the proclamation was not for changing the status of Jammu and Kashmir. And if it were, then it's a fraud on the Constitution. It's an absolute fraud on the Constitution if you admit that this had a nexus with your object on 18th of December.
In fact, to stretch your argument could be that the object of any proclamation under Article 356 can only be to ensure that the government of the state is carried on in accordance with the provisions of the Constitution.
As a stepping stone to restore full democracy in that state. I bow to your Lordship, I couldn't have put that better, very neatly. And I am very happy to adopt that line as my own. Now, in this behalf, my lord, if your lordship will state away, I'll rather than take your lordships into Bomai, in my lord's, the Honorable Chief Justice's judgment in opinion in Krishna Kumar Singh, if my lords are kind enough just to see that what is the judicial scrutiny required on Lord's a proclamation, presidential proclamation, Lord's, volume 21 of the case law compilation
Page.
at PDF 61, PDF 60, I'm sorry, because your lordships have,
Which volume, Mr. Singh?
Lord, volume 21, PDF 60, paras 55 and 56. Your lordships have set out,
This is 7 judges, right?
yeah, my lord's judgment was 7 judges, and your lordships have just extracted a very Lord's, apposite Lord's, portion from Bomai.
Page 60. Page 60. Which page?
Lord, PDF 60 in volume 21 of the case law compilation. Your lordships have it. Foot of that page, Placidum G, just one line above Placidum G, elucidating the approach of the court when a proclamation under 356 is questioned, Justice Jeevan Reddy held in Bomai case, para 373, whenever a proclamation under 356 is questioned, the court will no doubt start with the presumption that it was validly issued. But it will not and it should not hesitate to interfere if the invalidity or unconstitutionality of the proclamation is clearly made out. Refusal to interfere in such a case would amount to abdication of the duty cast upon the court, Supreme Court and High Court by the Constitution. The standard of judicial review was formulated in the following observations, Bomai case, para 374, and the truth or correctness of materials cannot be questioned by the court, nor will it go into the adequacy of the material. It will also not substitute its opinion for that of the president. Even if some of the material on which the action is taken is found to be irrelevant, the court would still not interfere so long as there is some relevant material sustaining the action. The ground of mala fides takes in inter alia situations where the proclamation is found to be a clear case of abuse of power or what is sometimes called fraud on power, cases where this power is invoked for achieving oblique ends. I'm confining myself to C2. I'm not, others before me have argued on the larger issue, but since I'm on the State Reorganization Act alone, I'm just keeping it as narrow as possible. C2, I submit, is clearly beyond the purview of the 356, and except for revealing the underlying intention of that proclamation, it does nothing more. C2. Now, in Rameshwar Prasad, a constitutional Chief Justice Sabarwal, then speaking for the bench in Rameshwar Prasad, at volume 3, PDF 96, if my lords are kind enough to come to that. Actually, PDF 95.
But, Mr. Singh, is the conversion of the state into a union territory, is it severable from the abrogation of 370 itself?
Yes, yes, it is. It is. The two are completely separate. Here, what has happened is that are relying on Article 3. They have by passing a simple law, simple parliamentary law under Article 3, a State Reorganization Act was passed. And
so your argument on the conversion of J&K into the two UTs, that would really survive irrespective of the decision on the abrogation of 370.
My submission starts with that this is completely independent of the abrogation. Whether J&K was from day one completely under the Constitution of India with no commas and full stops taken out of it, whether it was under 370 as applied to J&K, with any permutation
even
and
if you were
combination.
to exercise this power according to you in relation to any Indian state,
that's right.
This would be unconstitutional.
That's right.
Irrespective of the special considerations which apply to J&K in relation to 370.
Yes, yes, and irrespective of the proviso also, the scheme of Part 1 and read with Article 368, and I'll show your lordship it completely precludes such an exercise. Also, when I come to the history, your lordship will find that all right from the 1919 Government of India Act, 1935 Government of India Act, the precursors to Articles 3, 4, and 368, and then the Constituent Assembly debates, and then what came about. This was never the state, the powers given to the Crown initially, to the Governor General in 1919, to the Crown in 1935, and to the Parliament in 1950, were powers meant to mediate when a minority, perhaps in a state, made out a justifiable case for greater self-representation. Suppose there's a linguistic minority in a state, but they have a distinct area, like Haryana was in Punjab, or Himachal was with merger of princely states. The idea, or let us say there's certain other reasons where there are people who can't get a majority in that state assembly to accept, but they make out a case for greater autonomy, greater representation, for full statehood. Parliament, under Article 3 and 4, acts as a mediator. Because
how were the UTs born in
yes,
the Republic?
I'll come to that.
I think in my judgment in NCT 2, I've dealt with the whole history of how the UTs were created.
You have. But
and were the UTs, in other words, was there a peculiar constitutional history attached to the creation of UTs?
Yes.
And does that category remain frozen now?
In fact, that category has moved consistently towards full statehood. By the 4th of August 2019, there were only
the origin of the creation of UTs.
Yes,
then?
but look, may I?
We'll have to then, because that your argument will have to explore in this way. What is the history surrounding the creation of union territories under the Indian Constitution? Yes. 2, does that category then remain a sort of frozen category in the sense that you can convert a UT into a state, but you can't do the reverse process? That's the right. Second point.
And that is historically, that is what has happened. So by 4th of August 2019, there were 7 UTs left in India. And they were Delhi, Chandigarh, Delhi, Chandigarh, Daman and Diu, Dadra, Nagar Haveli, Puducherry, Lakshadweep, and Andaman. All other UTs were gradually, once they could become viable units, the moment an area could become a viable unit as a state, it was converted into a state.
What do we find? I mean, how were the UTs created?
Yes. So look, can I just then give your lordship the pages for this first argument, just so that
yes, certainly, and then we can move to the next.
So in
you're on Rameshwar Prasad until I.
Rameshwar Prasad.